call David Clendon.
Thank you, Mr Speaker. I'm very happy to speak to this Statutes Repeal bill. I think I got that right.
Good start.
Sir, it's a good and useful bill. It's a necessary thing occasionally to have a clear out of the statutory cupboard. New Zealand has been on occasion referred to as having the fastest legislature in the West. I think we're also one of the most prolific. There is legislation in this repeal bill that dates back over 100 years. It simply serves no purpose, and for that reason we support most of what we see in this bill. There is one considerable exception to that, however. If one goes to Schedule 1, page 7 of the bill, you find the Sentencing Council Act of 2007 is one of those to be excised from the statute books. And we are entirely opposing the proposition that we ought not to retain that legislative opportunity, because that's all it is so far. The bill was passed, of course. The Act came into being at the last Labor government towards the end of their term. This government has chosen never to actually put that into existence. The Sentencing Council has never been established. If it's repealed in this bill, then it never will be able to without yet another Act of Parliament. At the Select Committee stage, we will be supporting this bill to Select Committee, but at the Select Committee we will be arguing that rather than repealing this bill, that the national government should look at amending it to suit them, and that would be very much in line with the debates, their contribution to the debates at the time the bill was passed. They did, to be fair, the government's been consistent. They did oppose the passing of the bill in 2007, but as I'll come to later, the National Party in opposition didn't object in principle to the idea of a sentencing council. They simply proposed that the government of the day, the Labor-led government of the day, had got the wrong model for sentencing council. So we are very strong on the fact that we actually need a sentencing council. The primary function of such an entity, of course, is to even out sentencing, to ensure that there is a level of consistency. And I think it's a well-drafted piece of legislation as it sits. It doesn't take away Parliament's right to make law. It doesn't see Parliament interfering more than it ought to in the business of the judiciary. It does enable the judiciary to, within its own realm, come to some sensible guidelines about what sentencing should look like. And I think we've had quite recent high-profile instances where people have really questioned and challenged what appear to be significantly different sentences for offending by offenders where there seems to be a great deal of similarity. So we will, as I said, we'll support the bill to first reading, but we do think that it's a mistake to repeal the Sentencing Council legislation. The original Act, or the 2007 Act as it stands, was written in response to a Law Commission report at the time called Sentencing Guidelines and Parole Reforms, and the Commission published a useful report and a set of statements about why a sentencing council was both necessary and useful to have. So as I said, 2008, with a change of government, Simon Power, who was the minister at the time, referred to the council, and I quote, as just another layer of bureaucracy, and suggested that that it was unnecessary. But sadly, the very evident and measurable disparity in sentencing outcomes has been very obvious ever since then. And indeed, I would argue they are getting worse. There's evidence that we are getting considerable disparity in sentencing outcomes. And that's a very unfortunate outcome indeed. So I won't dwell on it at any great length, given the time available, but I would encourage people to go back to the 2006 Law Commission report headed A Sentencing Council and Sentencing Guidelines, a fact sheet. It's a good summary sheet of what the intention was, what the outcomes could be, and indeed what the nature of the problem was at the time. We roll forward a little to 2013. The Law Society published a report of a piece of PhD research done just 3 years ago and talked about massive differences in the severity of sentences imposed by district courts, and they used the example of aggravated drink driving offences. They controlled for things like the number of offences an individual may have committed, the severity of the offence, a number of other variables they took into account, and even allowing for those variables. They came to this particular piece of PhD research, came to the very obvious conclusion that there are serious and significant disparities depending on where one is sentenced. Often it's geographic, and it's also to do with the individual judges. That report has been anonymised, so it doesn't identify individual cases, individual judges, but it is a very compelling piece of work. It won the support of the Law Society, and I do believe it needs to be taken seriously. Sir, it's also informative to go back to the original Hansard of the third reading, particularly when the Sentencing Council legislation was passed. As I say, Mr Power at the time, Simon Power as he was, still is, who became Justice Minister, was somewhat scathing of it. He said that the Sentencing Council would become the District Health Board of the justice sector. And he suggested that the Minister of the day would be able to hide behind it if there was any criticism or critique of the operation of the courts. I think a close reading of the legislation indicates that's actually not a reality, that it would absolutely not protect a minister from reasonable critique if things were not working well within the court system. Sir Charles Cheval, for Labor at the time, of course, made the point that we had a very regrettable situation in New Zealand where people with similar situations come before different courts in different parts of the country, before different judges, and can actually receive different types of sentences, not only severity, but type. I would hope the Māori Party would also look long and hard at this Repeal Act, and specifically in terms of this Sentencing Council legislation, because Peter Sharples, Sir Peter as he is now at the time, I should say that this Sentencing Council legislation was one of a raft of bills which I think may have been debated as co-joint, wrong word, but you know what I mean. They were debated together as a raft of justice bills. Mr Sharples at the time said, and I quote, "The key measure to bring about change in the justice system as mandated by these 5 bills is the Sentencing Council." He went on to say the Māori Party supports the establishment of this new forum to ensure a consistent application of justice, whether one is sentenced in Whangarei or Dunedin, South Auckland or the South Island. He went on to say that he hastened to suggest that tangata whenua expertise must be considered a core priority in considering the appointment of membership, and that indeed would be a valid point at the point that we ever did establish such an entity. Sir, as I said earlier, Chris Finlayson, the current AG, of course, Attorney General, made a very typically well-informed and thoughtful contribution at the time, and he did say that Labor had got it wrong in terms of the model they chose for the Council, but he did not dismiss the idea or the value of having something like it. And I will quote him again. He said, "The National Party moved a great deal from complete opposition at the outset to offering a model that would have achieved the Law Commission's aims while still being constitutional." Earlier in his speech, he called it unconstitutional and odious. Splendid word. But I would ask the National Party members, and particularly its Select Committee, to reflect very closely on the speeches that were made, both in support and opposition to the Sentencing Council in the 2006-2007 debates, and think, well, maybe we're throwing out some babies with the bathwater here if we repeal the Act. I think there would be considerable value in retaining a council. We're entirely open to the notion of an amendment. It's perfectly possible that the model chosen upon was not the best, or potentially we might do it better. But we absolutely believe that there ought to be something like a Sentencing Council to endeavour to moderate, to ensure that the judges, the judiciary themselves, have a forum where they can look at sort of a level of self-awareness could emerge, I think, which could enable much better, much more consistent sentencing, and inevitably emerging from that would be much greater public confidence in the outcome of our judiciary, of our justice system. So I look forward to the Select Committee with interest, and I would encourage, as I say, government members particularly, to have a think about the potential for an amendment rather than appeal. Thank you, Mr. Speaker.